Mr. Chairman, we're live.
All right. Welcome to this morning's House Judiciary Committee meeting. Welcome, welcome. Good to see a nice full-size room. So hopefully we won't, hopefully we'll keep you on edge. We won't bore you too much with some of these bills that we have in front of us. I do have to make, before we call the roll, I just will make a correction to the notice. We did notice House Bill 0087, Insurance Investment Amendments. If you're here for that bill, we're not hearing that bill. So won't waste your
sigh.
Won't waste your time. That will be heard later this week. Okay, Carol, with that, will you please call the roll?
Representative Craigo.
Here.
Representative Larson.
Here.
Representative Oakley.
Here.
Representative Provenza.
Here.
Representative Rodriguez Williams. Vice Chair Washit.
Here.
Representative Yen.
Here.
Representative Zwanitzer. Chairman Olson.
Here.
All present.
Excellent. Okay, we'll dive right into our first bill, House Bill HB 37, Juvenile Justice Data Reporting. This was this comes out of one of our top priorities during the interim, studying juvenile justice. As a reminder to the committee, this bill is looked at as what we statutorily had on the books, a required reporting. And there was some confusion over the decades of time of whether that reporting was mandatory or not. And I think we cleaned all that up, worked through the statute, collected some data during the interim, or input some data anyway. And now we have a bill in front of us, and we've brought in a different agency as well. So anything else that I'm missing in the summary committee? Feel that's pretty good? All right. All right. We will move to the public and we'll move to our agencies.
Yeah, that's right. Yeah.
Don't get too excited too.
Charging the podium.
Good morning, Mr. Chairman, members of the committee. My name is Corin Schmidt. I'm the Director of the Department of Family Services. With me today, I have Lindsay Schilling, who is the Senior Administrator of the Social Services Division. As you explained, there's been a little bit of transition in the statute to shift the responsibility to DFS for collecting this data. And just some points that I'd like to make, and then I'm going to turn it over to Lindsay, is that as an update on our IT system, which is the basis of much of this discussion, it did pass through the Joint Appropriations Committee, so it is part of our budget. But a lot of this conversation really does hinge on our ability to get that system. If for some reason that doesn't pass, then I think we'll probably come back during the interim and ask you to reconsider some of this statute. However, in the meantime, we've done another thorough bill review, and we do have some proposed amendments based on some of the conflicts that we have with the proposed amendments and current statute in regard to our ability to collect and keep the data.
Hey, Director Schmidt, can you real quick remind me what is the name of your IT system?
It is the YCAPS replacement, and also called CCWIS, which is a federal acronym for the system. Sure. Outside of that, we did submit some information in regard to fiscal impact. We understand that this bill isn't effective until 2024, but we did note that we would need some positions in order to follow through with this, especially in regard to training local offices, county offices, and also in regard to analysis. So we don't have the capacity internally right now to do the analysis that this would require. So those are two positions that we would need, certainly because it's going to take a year or two to get this going. It's not something necessarily we need right now, but it is a need that will be brought back to you all once we get closer to implementation. And so with that, Mr. Chairman, I will turn it over to Lindsay to give you some more remarks on the bill, and then also to talk to you about the proposed amendments, and they're rather friendly, I would say, just more some technical cleanup based on how we operate. So thank you.
Thank you. Good morning. My name is Lindsay Schilling with DFS. I just wanted to touch a little bit on the fiscal note. There was one position in there. We also included money for statewide travel, 1 year of supplies, and then an initial amount for interface development, and then a small amount of money for ongoing interfacing and IT support. So that was all in that. In terms of the amendments, I hope there'll be just technical corrections based on the change from the Department of Criminal Investigation to the Department of Family Services. The first one I draw your attention to is on page 10, lines 15 through 20. It references the information being maintained by DFS for the purpose of this cannot include predisposition studies and reports, social summaries, medical or psychological reports, educational records, etc. If we were to leverage our case management system, those are absolutely documents we have for all of our open cases where we're required to collect them and to maintain them as part of our case file. So a prohibition on maintaining those for youth in our custody would be problematic. So I think our ask would be just to strike that entire provision, or add language that just excludes youth that have been part of a DFS case or are currently part of an active DFS case to allow us to continue having that documentation. The second one is on page 11, lines 18 through 19. This speaks to who has access to the data collected for purposes of this act. And it does state that DFS can only have access to information for youth who are in the custody of the department. Global and aggregate data reporting will be hard if we can't access the whole data set. So hopefully just a technical correction to strike that line.
Sorry, what line are you talking about?
Page 11, lines 18 through 19.
You want it? I have a quick question. Mr.
Yeah, please.
Thanks, Ms. Schilling. So my question is, do you want the current change to go back to Department of Family Services, or do you want us to repeal that entire Romanet 3 from existing law?
Ms. Schilling.
Chairman, Representatives Waters, our preference would be just to repeal provision 3. And then the last one is on page 12, lines 7 through 9. Talks about record deletion. When a subject reaches the age of majority, all the information in this data system pertaining to that youth shall be deleted. This provision actually conflicts with our current federal requirements for data and record retention for DFS cases, but also just something else to consider if we're looking at wanting to track youth across systems and what happens when they age out of care and they're over 18. Deleting the data would make that difficult.
Ms. Schilling, what is the federal regulation you're referring to?
So for our juvenile justice cases, we're required to keep those records. And right now we have them at least 8 years beyond case closure unless there's an expungement effort.
Sorry, to clarify my question, what is the regulation, the CFR or the statute? that you're
Oh,
talking
I would
about?
have to go pull that for you.
Mr. Chairman, the system, as Wyoming looks at its social services system, when kids come into custody, they become part of the foster care system. And so even though they're juvenile delinquents per the Juvenile Justice Act, they are considered for federal reporting foster kids. So all of that information then is reported to the feds. So their information is no different than a child that's been abused or neglected or a child in need of supervision. So we can get you the specific CFR, but my guess is it's under Title 4E of the federal law.
Yeah, I guess I'd like to understand the language of it. I'd like to understand if it, when you state that this provision is in conflict, my interpretation of what that statute would look like, it would say that you must keep the data in perpetuity or something like that. So I think it would be helpful to see that statute and understand if it is a strict prohibition. We obviously do not, well, it wouldn't matter. Obviously, you just follow the federal law, but we don't want to have that in conflict with federal law. But if it's not that they're polar opposites, but that they conflict in some other way, there may be a way to marry them and find something in between. So that's why I would like to see that. Vice Chairman Washington.
Thank you, Mr. Chairman. Is this language that's there now basically a holdover from when DCI was identified as a repository? And so eliminating them from a DCI database would be different than eliminating these records from a family services database. Is that an accurate assessment?
Mr. Chairman, Representative Washit, yes, exactly.
Other changes?
Mr. Chairman, those were the only three we had. And I just might mention too that we've worked with Donna Sheen and some of our external stakeholders on these, and they've been supported and agreed on by everyone.
Perfect. That's good to hear. That's going to make the meeting go real quick and easy. Okay. Anything else generally on the bill?
Mr. Chairman, just some general comments. I hope that the committee will give us a little bit of grace as we work through some of the technical parts of some of the technical parts of standing up our CCWIS system and trying to integrate all of this data. I do want to remind you that it does not include municipal court data. It just includes circuit court and district court data. Municipal court is really an important component of juvenile justice. Please don't hear me advocating that I'd like to pull all that data in right now. However, I do think as we work through some of the logistics through the circuit court and district court, that at some time, having a conversation about municipal court data is going to be important.
Vice Chairman.
Thank you, Mr. Chairman. Director, I call your attention, page 9, lines 2 through 5. If you could refresh my memory why we were striking all of that demographic detail about the descriptives on the individual. Is that something that you have a great opposition to including in your database? I can see some application for law enforcement perhaps and having that kind of information available. So just your comment why we were striking all that.
Director.
Mr. Chairman, Representative Washit, I think at some point we thought it maybe wasn't necessary in terms of data reporting and analysis. However, from a law enforcement standpoint, that may be important. So we just didn't think that the weight, height of a youth that's maybe cited at some point 5 years down the road, it's going to be irrelevant to us from a data analysis standpoint. However, I think maybe Byron Otakoven and Kara Chambers also have some conversation to add to that. We are indifferent. We'll collect whatever data is in there. However, I do think they had a conversation that maybe they may want to see something different.
Okay, perfect. We'll ask them about it when they come up. Thank you, Director. Thank you, Ms. Schilling. What other agencies do we have? Oh, oh. You're hiding back. You gotta come to the, yeah, you technically are.
Good morning, Chairman. My name is Kara Chambers. I'm with the Attorney General's office. Thank you, Representative Washut. As opposed to waiting for a question, I figured I would just answer the last one, if that's all right. We did have that discussion. You want to introduce yourself? Maybe.
Thank you, Mr. Chairman. Byron Odikoven, the Executive Director of the Wyoming Association of Sheriffs and Chiefs of Police. Yes, we can piggyback on the answer to that question. Do you want me to?
Yeah, either way, go for it.
I sense as we were looking at the bill, we're looking at changing kind of the where the information goes, i.e. to DCI. We can talk about the problems with the report for a while, but I think we got past that in the interim. And now transferring over to the Department of Family Services. This is fine. But I think in that step, as was kind of alluded to, that which you need for data statistical analysis is slightly different than you would for a law enforcement purpose. And that would be, in this particular case, it's the what if and the when it may, and what do I do and how do I do that? I.e. that child that's identified in the system as a delinquent becomes missing, or for heaven's sakes, ends up really missing as a found body. Most of those don't come with an identification card. We end up relying on this type of information to make that identification to work through the system. So it's a very morbid thought of why some of this information is necessary for the what ifs. It's certainly necessary information for that very what if. So it may not have value in terms of statistical information, but in some circumstances, it is the only valuable piece of information that we start that investigation with. So, Mr. Chairman, I would suggest we add that information back in. As I visited with you several before the meeting, if it's something, and I sense that you have in at least 2 places rulemaking authority for the division of family services going forward, because I sense as we work through this and we actually implement this, we'll find several other little pieces of information that we'll need to actually track. As long as they have that ability through rulemaking to make those modifications, we won't be back here asking for clarification each and every time something like this comes up. But I think it's important at the onset to note that this type of information is important, should be included, and then we can sort out how we do that a little later through rulemaking, Mr. Chairman.
Mr. Odikoven, my only question on that then is, in creating a longer list of things of data that has to be inputted, is that going to, do you feel like that's going to bring us back to where we were, where our local offices are concerned that they don't have the man/woman power to input the data? That's too much? Or is it, I mean, is it, I don't want to go backwards. I don't think it's burdensome myself, but I never thought it was burdensome, but I don't fully appreciate that system because I don't have to enter the data.
Mr. Chairman, it's my hope that we can replicate the process for submission of data to the Department of Family Services, much in the same way that we do the Division of Criminal Investigation, and that is electronically from our existing reports, with the ability to work with the vendor to supply that information that we would be collecting in the first place. So this is information we do normally collect now. It's part of our reporting system. So it would almost be counterproductive to have them write a report to exclude this information being submitted, as opposed to just submitting what we collect.
All right, very good. What else?
Chairman, I don't have much to add other than this became pretty apparent to us with the work that my office and agency is doing with missing people. If you look at DCI's missing persons website, the vast majority of the individuals on that are juveniles, age-wise. And so that would just be helpful. I understand the comment about weight and height. It's obviously going to change. And of course, we always do age progressions on missing youth, but the rest seems really helpful to us and seems, as Mr. Odekoven presented, law enforcement collects that data anyway. So it seems it would not be burdensome to keep that in versus redacting it. And I stand for any questions.
Perfect. Mr. Odekoven, are there any other, in your review of the bill, anything else that could be cleaned up? Gives you heartburn?
Mr. Chairman, at this point, no, mainly because we have 2 years worth of implementation. We have system issues to address and work out, depending upon the grace that you have in regards to the funding request for the Department of Family Services ability to upgrade their computer system will in fact have an impact on how this goes. So I think we'll be back to discuss it depending upon your decisions with the budget, how this may or may not flow and go. So at this point, I think we're okay, Mr. Chairman.
I feel like the department may have strategically timed all this. Now they've got on top of appropriations committee batting for them. Now they're going to have joint judiciary wanting the appropriation as well. So,
Mr. Chairman, we would all like information in the best form that we can have it. And it takes a little computer time and expenditure to be able to do that. Thank you, sir.
all right, thank you. Carol, can we bring Machine in? We're just kind of teeing her up. Any other agencies? Anyone else here to testify on this bill? Yeah, come up.
Morning, Mr. Chairman, members of the committee. My name is Beth Lance, and I am here today on behalf of the Wyoming Trial Lawyers Association. We are in support of this bill. Many of our members work in the area of juvenile justice and represent children in these circumstances under the law. And we see this as valuable. We certainly have supported in the past other juvenile justice bills for juvenile justice reform. And I see this as a good tool to hopefully continue to move towards more juvenile justice reform in the future, particularly in order now that we would have potentially so much more data, we would have a better understanding of the gaps in the services for our juvenile offenders. And particularly, as I know this committee has heard many times before, alternatives for detention and things of that nature. And so it is our hope that this bill would just help facilitate that information to better serve our youth.
And I think it will, Ms. Lance. I heard in the state of the judiciary that the Supreme Court has decided to form an entire committee to look at juvenile justice. So I think the whole state is now very interested in it.
I appreciate that. Thank you.
Thank you. All right, do we have Machine in the? All right, Machine, you can light up your camera. Welcome.
Thank you, Mr. Chairman. I'm Donna Sheen with the Wyoming Children's Law Center and also representing a group of stakeholders and advocates that we call our Wyoming Youth Justice Coalition. I first want to thank you. This is a monumental step in us really being able to do an effective job reforming our juvenile justice system. We need to understand what happens to youth in our system first, and then be able to find out what outcomes, what interventions give us the best outcomes. And so without this critical initial piece, we'll have very little luck, I think, turning our system around. I do just want to comment a little bit on the fiscal note. I know sometimes that may give people pause in terms of these kinds of initiatives. And I just want to remind everyone that we continue to have very high youth confinement rates. which we believe if we were doing a better job of really identifying youth who need to be in placement, we could save the state millions of dollars. And so this is a first step to being able to identify those youth that need to be in confinement and avoid confinement, expensive confinement for those who can be better served with lower cost interventions in the community. So I think it is definitely money well spent in terms of collecting that data. And I would remind the group that we do have an infrastructure to a certain extent in most counties through the Community Juvenile Service Board that is already collecting and does have systems in place to be able to input data, because DFS does require data for those counties to be able to receive the funding. Now, we, as some of you know, we are trying to restore that funding to keep that piece of our system in place while we look at bigger reforms in the future. And so I would just add that that's a component that it would be very helpful to keep in place for now, and potentially would cover some of the cost of collection that Ms. Schmidt talked about. As far as the amendments, we certainly support all of the amendments. They're just basic cleanup that makes sense. And in terms of the demographics, I do think it would be wise for the committee to give the department some leeway through the rulemaking process to adjust what data is collected in order to recognize the fact that certain data we may not think about today could be very helpful in the future. And having the rulemaking authority would be important in order to change that more quickly. And with that, I thank you again for taking this up, and I would stand for any questions.
Any questions for Ms. Sheen? Vice Chairman Washut.
Thank you, Mr. Chairman. Ms. Sheen, you referenced efforts to put some funding back in. Is that a bill that's being drafted somewhere, or is it included in the budget bill? Or is it still not yet formalized?
Mr. Chairman, Representative Washut, we have talked with a couple of representatives. Representative Conley and Swanitzer have agreed to get a draft going for a bill amendment, or a budget amendment, excuse me, to put that money back in to the DFS budget. I think there may be other avenues that people are discussing. We've certainly talked a lot with both some of the senators and representatives on both sides. And I do think there could be other ways of being able to maintain those community juvenile service boards, perhaps through the some of the emergency federal dollars as well. And so it's our hope that we come up with a solution within the next few days. And I will try and keep members informed of what those strategies are.
Committee, anything else? All right. Thank you, Ms. Sheen.
Thank you.
Any additional public comment on this bill? Ms. Somerville.
Good morning, Mr. Chairman, members of the committee. Andy Somerville. I'm the executive director for WAMSAC, which is the Wyoming Association of Mental Health and Substance Abuse Centers. And I just want to testify briefly as what I would call a stakeholder partner. Occasionally the stars align in Wyoming, and just next door earlier this morning, House Bill 33, kind of version 2, continued behavioral health reform, passed out of committee. Why I want to mention that in this bill is because that bill and the previous bill, House Bill 38 from last session, identifies families at risk as a priority population, and specifically speaks to those that are at risk of becoming involved in the juvenile justice system. And we certainly think that all of our partners need to be involved and at the table to try to improve those outcomes for our juveniles and serve them correctly. And we certainly think that this is a good way to make some forward momentum on that path as we do our job on the mental health side to also support our partners and DFS in collecting data and getting a better picture of what's going on in the state. So, Mr. Chairman, with that, I would stand for any questions.
Committee, questions for Ms. Somerville? All right,
Thank
thank you
you.
very much. Last call. Any other public comment? No? Oh. All right. With that, there's no one else, Carol, in the virtual world. All right, I will close public comment. Committee, what is your pleasure?
Move the bill.
Moved by,
Mr.
oh, yeah.
I'm out of practice. Mr. Chairman, I would move House Bill 37.
It's only the third day of the 18th year.
Yeah.
Moved by Representative Zwanitzer, seconded by Representative Provenza. All right, committee, we do have a series of amendments on this bill, so let's just let's go through any amendments on page 1. Page 2.
Yeah.
Okay, page 2.
Mr. Chairman, I just call the committee's attention to the fact that on page 2, line 12, we talk about the department promulgating rules. And then again, clear back on page 13, lines 1 through 3, we talk about the department promulgating rules. It seems a redundant inclusion there. So I think my approach will be to strike the language on section 6 on page 13 and just leave page 2 as is for now.
All right, hold on a second. Let's look at this. Are they different scopes? So section 6 is all rules necessary, which would probably encompass, you're saying would encompass whatever is inside of B.
Mr. Chairman.
Representative Zwanitzer.
Just in general, I think the subsection beyond page 2 is for an ongoing, should something change, they don't have to come back to the legislature and ask for additional rulemaking authority. It's kind of a continuous improvement as we evolve. Separately from section 6, which is anything in this act dealing with a repeal or renumbering. I don't know what that would be, but I think that's the difference, at least in LSO's mind when they drafted it. The thing on page 2 is for kind of continuous improvement without coming back to the legislature to have to ask us to do it again. But I don't see any actual current necessity on why section 6 is needed on page 13. So certainly ask the department.
Well, I definitely think, yeah, I don't know. Section 6 is obviously, you're saying section 6 isn't an ongoing because it's just, because it's not codified.
Yeah.
It's not codified.
Anything they need to change to report with the bill.
The codification of the section under 14.6.606 allows them at any time to make rules. So I do agree with Representative Zwanitzer, Vice Chairman Washit, that they are different rulemaking authorities.
If we want to give it to them.
If we want to give it to them. I think the question is not that they're in contradiction or that they're duplicative or superfluous, but that there's a question of whether you want ongoing rulemaking authority for this department. Representative Yin.
Mr. Chairman, thank you. I think that the section 6 is actually necessary because the one that's on page 2 is specific to section 1, but there are 4 other sections with statutes that have changed and even a new article. And even in the case where Mr. Odakoven and Ms. Chambers talked about, having rulemaking authority to make sure that they can add new things that may need to be put into the system for section 3. I think section 6 is necessary so that they can have that rulemaking authority. So I do think the scope is important. That page 2 scope is specific to that section, but you need the section 6 to cover the whole bill. Thank you, Mr. Chairman.
Mr. Chairman,
Yes.
Pleasure of the committee. I don't think it hurts the bill to have it in there twice. I'm not sure it's necessary, but I don't think it hurts the bill, so I won't make any amendment to rulemaking authority.
All right. Any other amendments on page 2? Page 3? How about page 4? 5? 6? 7? 8? Yes, Vice Chairman Washington.
Thank you, Mr. Chairman. On page 8, line 2, we're talking about the report that DFS will provide to Joint Judiciary each year. And it seems that it's limited to the number of entries and usage of the database. And so my proposed amendment would be after the word entries, we strike the word and, insert a comma before the word usage. And then on line 3, after database, we strike the period, insert a comma, the word and, then include overall compliance with this act, period. And that would allow the department to give us a summary of compliance, which was one of the issues that we ran into with the previous system. There was no double check to find out whether all the parties were complying with the statute. So Carol has a copy of this amendment, and that'd be my proposed amendment.
Seconded by Representative Provenza. Does everyone understand the amendment? Are there any questions on the amendment? Question on the amendment? All those in favor signify by saying aye.
Aye.
All those opposed? That amendment is adopted. And you do have a copy of it, Carol? All right. Any further amendments on page 8? Page 9? Vice Chairman Washington.
Thank you, Mr. Chairman. On lines 2 through 4 of page 9, I would ask and offer an amendment to remove the strikes on all the physical descriptors that were listed there on lines 2 through 4. So my amendment is to remove the strike language on those lines.
Unstrike the strikes.
Unstrike the strikes.
Seconded by Representative Williams. Committee, any discussion on unstriking the strikes? All right. All those in favor signify by saying aye. All those opposed, that amendment's adopted. Any further amendments on page 9? Page 10. Need an amendment to page 10. Vice Chairman Washington.
I believe Director asked us to look at lines 15 through 20.
Yep.
And I would move that we would strike all of the language in lines 15 through 20 from this bill.
Seconded by Representative Oakley. So striking subsection B. Discussion?
Mr. Chairman?
Yes.
Just want to make sure you want to repeal the entire section out of current statute is a motion. It's not just to change the new language. It's now that it's going to DFS, we don't need.
Thank you for the clarification. That would be my intent.
Yeah. The department presented 2 options. You could repeal this section, or you could add language that basically addresses youths who are in open cases with DFS. Your motion is to repeal.
That's correct, to repeal.
Okay,
Question.
we've got lots of seconds, so we are ready for the question. All those in favor of the question signify by saying aye. All those opposed, that motion carries. Any additional amendments on page 10? Oh, yes, Carol,
I just want to be clear. So we're taking section B completely out. Is that correct?
correct.
Thank you.
Amendments on page 11. Amendments on page 11. Representative Larson.
Mr. Chairman, I think they had mentioned the agency that they would like lines 18 through 19 repealed.
Mhm.
I'll make that motion.
Okay. It's moved and seconded by Representative Oakley to remove lines 18 through 19 on page 11. Discussion on the amendment.
Redundant.
It is redundant. All those in favor of the amendment signify by saying aye.
Aye.
All those opposed, that amendment is adopted. Amendment on page 12. Who wants this one? Vice Chairman Washit, you like amendments today.
Thank you, Mr. Chairman. Line 9. After the word deleted, insert a comma and add the phrase unless retention is required by federal regulations, period.
Yeah, I'll second it, I guess.
Okay, seconded by Representative Zwanitzer. And would you allow, in the motion, would you allow latitude to LSO to conform that with any,
Certainly.
yeah. Representative Provenza, discussion on the amendment?
Yeah, thank you, Mr. Chairman. But one of the things that was mentioned in conversation, I believe here earlier was if we're going to look at the latitude of how, if someone is rehabilitated, say, so they get out of the boys' school, then tracking that to see if maybe they've gone to DOC and the concern that maybe that data wouldn't be available. I don't know.
So are you suggesting that you would rather just delete this section?
Mr. Chairman, I believe that's what the department testified to.
What would you like to? do,
Yeah, I mean, I think,
Representative
thanks. I don't want to screw up the bill is all. So I guess what I would want to do is delete this section
Provenza? Okay,
to allow for that.
Motion on the floor.
we do have a motion on the floor. So Craigo, do you have discussion on this amendment?
Well, I was wondering if I could ask the director a quick question regarding this particular amendment.
I suppose.
Thank you, Mr. Chairman.
Director Schmidt?
Mr. Chairman, Representative?
Representative Craigo?
Mr. Chairman, Director, I was just curious, is there a circumstance outside of federal law where we would, as a state, want to maintain those records? Not necessarily for the juvenile justice side of things, but for the other part of your department, if we're mixing those two systems together, is there a reason why we would want some of those records, regardless of what the federal law may or may not be at that's subject to change? So before we tie it directly to federal law, I'm just curious if there's a reason why we would not want to do that.
Director Schmidt?
Mr. Chairman, Representative Craigo, I think it goes back to Representative Provenza's conversation about longitudinal data to be able to track outcomes. And so if it is tied specific to federal language, it's only going to be a subset. It'll be the data that we would collect otherwise through DFS. It wouldn't include the data that's collected through circuit and district court. So within juvenile court, we have our own retention records. And through our laws, through federal laws, we have retention. What's happening is you're taking juvenile justice data that we've never had, bringing it in. So I think the policy question is do you treat now that data the same as we already treat the Juvenile Justice Act data? or do you want to keep it separate and apart? And just for an editorial comment, a few years ago, there was a lot of discussion about juvenile, help me out, attorneys, it's when you strike all of the record expungement, thank you. There was a long conversation about expunging juvenile records, and I do think maybe there's a potential that we need to look at that statute just to make sure. I just thought of that, otherwise I would have brought that up a long time ago.
Yeah, Director Schmidt, thank you for, that's my focus on this provision is I'm curious about the discoverability and the use of the data later on. It's access through requests, et cetera. So that's my curiosity to it is, and I don't know if you can speak to that.
Mr. Chairman, I'm not an attorney, so please forgive me if I, and the AGs that are listening. Under Title 14, under the 3 acts, the Child Protection Act, the CHINS, the Child Unneeded Supervision Act, and the Juvenile Justice Act, all of that information is confidential because it is within Title 14. So if it's information that we're collecting via Title 14, it's not going to be discoverable with it unless there's certain parameters. There really is, I think, a bigger policy conversation about what to do with the data from a longitudinal standpoint for those coming in through criminal charges in district court or in circuit court. That's public record to some extent anyway, so I don't know how much that matters in terms of confidentiality, but expungement is something that that needs to be considered. Little bit more background on expungement. We keep our information for 10 years per the expungement statute. If we get a request for expungement, we will do it automatically after 10 years. The reason for including that provision was because we have to do federal reporting and we use federal dollars to pay sometimes for the services provided to that child. So we wanted to give ourselves some time to close out the grant, be able to report to the feds before all of that is automatically expunged. So there is some conversation.
Director, could you flip this and say that all data, when a subject reaches the age of majority, all of the data shall be maintained unless, or may be maintained unless otherwise subject to expungement?
Mr. Chairman, I think that would be fair and perhaps then also subject to federal
And subject to federal
law
requirements.
as Representative Washit mentioned. Yes. Another option, and I don't know if we can do what I'm saying, but is if we could potentially de-identify at some point, the information would be helpful. You know, certainly we're never going to report names and identifiable information. This is all going to be aggregate data. So there may be an opportunity at some point once we start to look at our system to be able to create an identifier, so to speak, so that we could look at that longitudinally. We are looking at that anyway because we'll have to interface with the court systems and Medicaid for our CCWIS requirements. So there may be a potential with the data that's coming in from district and circuit court that we could create some sort of identifier through the information that's given, last name, date of birth. There's some common elements that you can look at to kind of ensure that the person you're talking about in one data set is the person in the second data set. But that's getting ahead of us in terms of being able to build out the system, but that is also potentially a potential.
Yeah, that's definitely the solution, long-term. Representatives Warrenser?
So, and neither of us are attorneys, but so question, if you're a 16 or 17-year-old and you get committed to a treatment or ordered to serve probation or placed in a plan of supervision or ISP, when you hit the age of majority, does that automatically go away? Or can we commit a juvenile who, I shouldn't say commit, encourage, hold, whatever it is, past their 18th birthday on a plan or an order And it would be a bad idea to immediately expunge all of those records if they're still under some type of court-ordered treatment plan. How should that work in the statute? Because you certainly, if someone's in a continuing case, you don't want to delete it as soon as they turn 18.
Director.
Mr. Chairman, Representative Swanitzer, I think again, it's the difference between the juvenile court data and the data that's coming in. Under the juvenile court, we already have protections. We have that data. We will keep it, until 21, or the case can remain open per 21 per judicial order. So I don't see that being a problem under current statute. Again, it's this idea that we're bringing a whole new data set into our system thinking around the confidentiality we have currently for Title 14. I think that this was probably going to be something we would discover as we work through rules, really fine tuning that. But it is going to have to be adjusted to some extent.
Vice Chairman Washit.
Thank you, Mr. Chairman. Director, I think what I just heard you say is that we could eliminate this section B and that this topic would already be addressed elsewhere in statute in terms of retention of records. Is that an accurate summation?
Mr. Chairman, Representative Washit, I am not overly familiar with Title VI, where this came from, and now is being converted into Title 14. So I don't know what it would do in terms of Title VI, if I'm understanding the question. I don't know if I could answer that.
Think just a quick follow-up. So if under Title 14 presently, the confidentiality of this information is already addressed in statute, would it be necessary to add additional language in this bill? Aside from Title 6, under Title 14, you are familiar with the confidentiality provisions already there. Do we need to add more in this bill?
Mr. Chairman, Representative Washit, that's a really good question. So the confidentiality provisions really start at the point of investigation. So when a petition is filed, even before a petition is filed, when we start to investigate cases or we start to look at them, that's when the confidentiality starts. So it doesn't start after we keep the record, so to speak. It starts at the very beginning of the case. In some respects, this data is happening, collection is happening outside of Title 14 under Title 6, which are the criminal side. And again, I think maybe we could look into that a little bit deeper with our AGs, but essentially I think what the question is does the protection of Title 14 apply to all data within this system, regardless of where it was originally collected? That maybe is what we're trying to get at.
Thank you, Director. Committee. Vice Chairman Washit.
I'd like to withdraw my motion for an amendment.
Okay. Who's the second? Are you okay with that?
Yeah, I'm okay.
All right. All right. I believe whoever the second was is okay with that. Okay. Do I have a different amendment?
Mr. Chairman,
Yes.
I would motion to delete lines 7 through 9 on page 12.
Okay. Moved by Representative Provenza and seconded by Representative Swanitzer to delete lines 7 through 9.
And Mr. Chairman,
Yeah.
I believe she means repeal line 7 through 9 from current law.
She doesn't want to just strike it. What do you mean? Because
Mr.
that's
Chairman,
existing statute?
Well, we're changing a current statute over to a different numbering system, so it's in current law, so under DCI, but I just want to make sure I understand what I seconded. I believe she just wants that out of our laws entirely. So it's more of a repeal It's kind of weird when you're changing the title, if it's even I'm kind of at a loss when you're changing it from one section to another. I still want it repealed and out of the statutes, I believe is the intent. So I'm going to say it's a repealer. Even though it's a change.
Mr. Chairman. So because it is existing statute, and as the bill is written, it's just striking, renumbering. I would say if you just delete it from the page, it's unsure whether it would still be in the act when it's renumbered. And so I think the amendment is meant to just strike it completely and read letter as appropriate.
Well, why don't we ask the mover? Is that your intent? Is Representative Provenza is to repeal this from statute, to repeal subsection B from statute?
Yeah, and I think if we see that that's a problem, Mr. Chairman, I'm happy to kind of work that amendment when we get to committee of the whole. If we see that that has unforeseen circumstances or consequences. So repeal.
Okay. Probably just saves a little bit of effort from hitting the delete button by somebody somewhere in some office. Okay, the motion, Carol, is to repeal subsection B of what is now 14-6-604. And it was moved by Representative Provenza and seconded by Representative Swanitzer. Discussion, we already had the discussion on the motion. All those in favor signify by saying aye. All those opposed, that motion carries. Any other amendments on page 12, committee? Page 13. Discussion on the bill. Carol, will you please call the roll call vote on House Bill HB 0037 Juvenile Justice Data Reporting?
Yes. Representative Craigo. Representative Larson. Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams. Vice Chair Washit.
Aye.
Representative Yen. Representative Swanitzer. Chairman Olson.
Aye.
9 ayes, 1 no, do pass with amendments.
All right. Next bill committee is House Bill 0038, Contracts and Restraint of Trade. Our very own Representative Stiff, appropriator. Welcome back to the House Judiciary Committee.
Mr. Chairman, thank you. Members of the committee, I want to thank you for taking on this topic, and I just want to speak briefly in support of House Bill 38.
All right, yes, I'm sorry.
I sent an email yesterday to you, I believe, that contained as an attachment proposed changes that were submitted by, I believe, by the Association of General Contractors or one of their members.
Yes.
And I wanted to comment on those because I think some of those proposed changes make sense and others don't. So, for example, on the biggest proposed change on page 5, line 1, there's an exception for executive personnel in the current draft. Page 5, line 1, you have an exception for executive personnel. If you are going to keep that exception, then it probably does make sense to take a stab at defining what executive personnel means. In my view, a narrow definition is better than a broader definition, because I think the purpose of an executive personnel exception is that chief executive officers may have more bargaining power, and they also may be privy to the company's strategic direction, and so they may have more ability to damage a company if they leave. So let me start with what my proposed definition of executive personnel would be. I would limit it to chief executive officer and chief operating officer or president of the company. Keep it pretty narrow, tight at the very top.
Representative Stiff, do you know, or did you look through the statutes by chance? Is there anywhere else where we might already define that?
I'm not aware of anywhere else in statute where the phrase executive personnel is defined. The proposed definition from the Contractors Association, which they've put on page 3, after line 22 in their proposal, my heartburn with that definition is that it's really broad. It includes all managers. And so it would sweep up the manager at the fast food restaurant who really doesn't have, bargaining power, frankly, to say no if they're asked to sign a covenant not to compete. I think another problem is that I think there's a confusion or conflation between protecting trade secrets on the one hand and a covenant not to compete on the other. The bill draft, as drafted, does not give anyone a license to steal your trade secrets, right? And so that part of the law remains unchanged. Their proposed definition would say that if you have access to a company's trade secrets, then covenants not to compete would be okay. I find that problematic because the most common type of trade secret in a business is your customer list. So if you're an investment advising firm, your client list is your trade secret. So this bill as drafted already doesn't give an employee a license to go out and steal the clients. You could still have a valid contract that said, don't solicit my current customers, don't steal my trade secrets. And that would still be valid under the current draft. So up to your judgment, whether you want to have a definition of executive personnel at all. But if you do, I think it would make sense to have it be pretty tight and narrow and for the very top level employees. One other recommended change by the Contractors Association that I think is a good one in principle, they added the word assets on page 4, line 13, page 5, line 23, and page 7, line 4. My tweak to that is I think it makes sense to have the phrase be if you are selling substantially all of the assets of a company, not just an asset. So if you want to add the word assets on page 4, line 13, I think it'd be better to say substantially all of the assets. I think that'd be cleaner. And since you've already defined what substantially all means, I think it ties in nicely. Finally, on page 5, line 14 of the current draft, there's an exception or there's a clawback potentially for signing bonuses. The current draft of the bill says that if when you start the company and they give you a signing bonus, that it would be appropriate or to have a clause that said if you leave within a certain amount of time, we can claw back the bonus. And in thinking about that, it might make sense to put a dollar limit on that because I think the target here, or the people my view is that this would protect, like say, hospitals who pay a really large bonus, like a $200,000 bonus to a physician, and they have some legitimate interest that the physician not jump ship within a month. And so that's the kind of the purpose as I see it. I think it would be unfortunate if this applied to kind of frontline workers at a convenience store or at a fast food restaurant who get a $500 bonus. It seems like it'd be a little harsh on them when they leave in 2 months to try to claw back that $500. So you might want to put say a signing bonus more than X dollars and then pick a number, whether that's $1,000 or $5,000 or something to think about. I don't have strong feelings about that, but that might be a way to avoid an unintended consequence that might punish a fry cook unintentionally.
Representative Stith. So help me track that. So the fry cook doesn't generally have a contract for employment, right?
Mr. Chairman, that's correct.
So they're probably outside of the purview of this bill anyway.
Mr. Chairman, that's correct. And frankly, yeah, if you just leave it alone, that's fine with me, but it would only be in the event that for some reason a fast food joint started having their employees sign contracts on day one that said, we're giving you $1,000 bonus. And by the way, if you quit within 3 years, we're going to claw it back from you. That might be a little onerous on the fry cook, for example. But your choice. I don't have, whether you take it or leave it, I suppose. I think the exception for clawing back the signing bonus does make sense for the high dollar signing bonuses. I think that starts to weigh a little more in favor of allowing the clawback. The other proposed change by the Contractors Association was that they wanted to put a little more specificity onto the phrase, what it means for the ex-employee to carry on a trade or business. I think they had added the phrase own, manage, operate. And if that suggestion might add some clarity. But the big one, I think, is executive personnel. That's the most important, difficult issue to deal with. Colorado, as you're aware, does have an executive personnel exception. But the problem in Colorado, in my view, is that it's led to a lot of litigation about what executive personnel means. And so, there's one case where the regional sales manager for a satellite TV company was held to be an executive personnel. And that seemed to be a little unfortunate in my view, because I don't think the goal of the executive personnel exception is to just prevent salespeople from changing jobs. So, Mr. Chairman, I've talked a lot, but do you have any questions for me?
Did you, I interrupted you, Representative Stith. Did you give us a specific definition for executive personnel? Is it in your email or?
I believe, yes, but it was pretty simple. The proposal would be that executive personnel would be chief executive officer, chief operating officer, or president. That's really narrow. I mean, if you want to expand it, the more you expand it, the harder it gets to define.
Mm-hmm.
Mr. Chairman.
Vice Chairman Washit.
Thank you, Mr. Chairman. Representative Stiff, you're going to have to help my memory. This summer, we talked about professional folks as well as executive folks. And that, the doctor at the local hospital might have the same kind of bargaining power that the executives have. But we don't talk about the professional folks here. Can you enlighten me as to why we didn't include that in the bill?
Mr. Chairman, Representative Washit, in general, I'm not in favor of excluding any particular profession. I don't think that makes sense. I think it's a lot cleaner if it applies to everybody. Part of it is the investment that the state makes in their training. Like we invest money. So nurses are professionals. We invest money to train nurses. In our current system, it's kind of allows and provides for the nurse, after having been trained by taxpayer expense, to then separate from their employer and be forced to leave the state. And that's it sort of damages the state's return on its investment. And for physicians, we have a similar issue with the WWAMI program. We spend a lot of taxpayer dollars training doctors, and part of the deal is they come back to work here in the state. And yet right now, if they are signing a covenant not to compete, then what happens is that we've spent a lot of money investing in that human capital, training them as professionals at taxpayer expense, and they may be encouraged to leave the state or certainly leave the community. So from my point of view, I don't think there's any systemic reason to exclude professionals as a group. That's just my take on it.
Thank you, Representative Stith.
Mr. Chairman, thank you so much. I really appreciate all the work. You've put a lot of work into this. Thank you.
All right. Mr. Boley.
Mr. Chairman, committee members, I'm Eric Boley, President of the Wyoming Hospital Association. And I hope I sound as good as I did at 4 o'clock this morning when I couldn't sleep. I got sucked into this unknowingly. We were in your committee talking about Title 25 when Representative Stith introduced this bill, and then suddenly it became a big matter for us. And it's not the first time that we faced this. Several years ago, there was an attempt to pass legislation through the Joint Labor Committee that had to do with non-competes for physicians, which was ultimately defeated. I've talked to a couple of you. I've sent emails, and you now have a copy of a study that was done by Merritt Hawkins, which is one of the largest physician recruiting firms in the country. And to be honest with you, I didn't realize that there was an executive order signed by President Biden in July that dealt with non-competes, and it's broad-based. It's not just physicians, but because that's kind of where we lie in our business. Merritt Hawkins did a study of what the executive order looked like, and then what the ramifications would be, and simply said that it looks like even under President Biden's executive order, there will be some leeway and some carve outs when it comes to physicians. And I think we've talked a little bit about the reasons I think this is important. One is hospitals and clinics and general physician practices spend a great deal of money recruiting. Merritt Hawkins recruits a tremendous amount of physicians here into our state. I also sit on the Wyoming Health Resources Network Board, which is a state-funded recruiting firm that helps place the WWAMI students. And they're a viable and a very valuable commodity in our state. But Merritt Hawkins, just as an example, it costs somewhere between $30,000 and $50,000 for a hospital to recruit a physician. That's what Merritt Hawkins makes. Normally sign-on bonuses, relocation expenses, continuing education, malpractice insurance. There's a tremendous amount of investments that go into bringing physicians in. And when we recruit these physicians in, our intent obviously is to keep them and help them have a thriving practice. Return on investment, somewhere between 2 and 3 years normally. Sometimes it's longer, depending on if it's a specialty that we have to start up. So I guess the ask, and it's been our ask all along, is I don't have any problem with non-competes in place for nurses. I actually understand the case that Representative Stith has referenced. It was a home health agency, and I think that the court system took good care of that. I've stated numerous times, hospitals, nursing homes, clinics normally don't put any non-compete agreements in place for nurses. We actually usually offer them scholarships and do all we can to get their training up so that we can keep them employed and take care of the patients that we do. But as you can see from the study that was done by Merritt Hawkins, physicians have significant bargaining power. And in some of your communities, you'll even see where this has happened, where physicians have come in and then they've set up direct competition. What a lot of times they'll do is they'll take the high paying insured patients and go to a surgical center and leave the non-paying patients to be taken care of by your community hospitals. And so I think to a certain degree, non-competes make some sense. And they're not as onerous as a lot of times we think they are, but they are there to help protect the investment that's made. And it's a continuing investment. It's not just a one-time thing. There's $5,000, $6,000, $7,000 given yearly to help them keep their education up, to get continuing education and stay board certified. It's a partnership. And so I think as we look at maybe what some of the contractors were saying, we talk about executives. I also think that, for some of these highly trained, highly qualified professionals, maybe we should take a look at it and maybe even codify what the Biden administration is thinking about doing with their executive order, which would be to exclude physicians. With that, I'd ask, or I'd answer any questions that you have.
Yeah, Representative Oakley.
Thank you, Mr. Chair. Thank you, Mr. Boley. I'm sure we discussed this, but so what's the standard length of the non-compete? Like you just mentioned, with physicians, you said the return on investment is 2 to 3 years. Is it limited to that? And then, I'm going to ask you if you do the renewals.
Mr. Chairman, Representative Oakley, it's a great question. And we did talk about it. Normally the first contracts are 2 years, and then depending on how it's set up different in different facilities. But normally they do work on renewals, but they go through a contract negotiation normally over salaries and other things at the end of that 2-year period. And most of the time it's a 1-year review in most cases. And so they have the ability to renegotiate contracts at the end of the 2 years.
Thank you, Mr. Chairman. Mr. Foley, you heard Representative Stiff's description of a WWAMI student being recruited to a hospital, perhaps in Wyoming, and then a non-compete clause forces that individual to leave the state. Could you speak to that scenario?
Mr. Chairman, Representative Washington, it's a great example. And honestly, the Wyoming students have a 3-year obligation, I believe, to work in the state to repay their student loans. I know our hospitals do all they can to recruit those and find placement for them. I don't think there's ever the intent to force them out of state. And I'm not aware of too many contracts that have been enforced against WWAMI students. And maybe that's something we need to take a look at. Maybe that's another one of these areas where it makes sense that until they've got their student loan repaid or something to that effect, we don't have them enter into the non-compete. I'm not sure. I mean, it's all over the board, but I haven't heard of many cases, if any, where a WWAMI student's been forced out of state. Or a WWAMI graduate, I'm sorry.
Mr. Mr. Boley, if we wrote in an exception for physicians, exempting them out, would your association support the bill?
We don't have any problem with it, Mr. Chairman. I do think that there's some ambiance here though. So we talked about physicians specifically, but I do think that physicians assistants, CRNAs, nurse practitioners, so providers of care that have negotiating power. And I think physicians doesn't capture it all. So one of the things I talked with our legal team, who actually represents hospitals and helps enforce some of these is maybe it makes sense to do a compensation amount and it shouldn't just be specific to physicians. I don't think. I actually think there's a lot of people not at the table right now because they're not really aware of this bill. Other businesses, but maybe we need to take a look at their overall compensation or something to that effect. And it's just one idea that I have.
Yeah, you just hit the nail on the head. If everyone comes to the table, everyone wants an exception. The clawback on the bonus, do you not see that as a reasonable solution to the physician or the nurse practitioner or whoever?
Mr. Chairman, actually, that's normally part of the part of the contract. It's agreed upon when they enter into those. So it's not out of the ordinary. It's actually usually part of what's considered or talked about when they talk about contract.
Okay. Did you send us an email or give us a list of who should be accepted?
Mr. Chairman, I didn't.
I'm not wild about one of your comments of just codify the President Biden's executive order, but if you had for a lot of reasons, but if you had a list that we could look at to consider, I think that would be helpful of who you're thinking of.
Mr. Chairman, it was tongue in cheek, the fact that I want to codify the Biden executive order.
Thank you for clarifying.
But that's the road we're headed down. We're actually headed down, making it even more stringent and more restrictive than what the Biden executive order, based on what they're saying right now and what his legal teams and what his teams come up with. We could potentially pass something more restrictive than his executive order. I think we'd be fine if we settle on physicians. I'm just making the point that there are other areas. And I think when you look at dentists, you've got the Witchy program. There's other programs out there that aren't represented here. And I'm trying to bring to light that I think maybe we've got the cart a little bit before the horse here, because there are others that maybe we should be considering and talking about when we talk about investments that are made through the school programs and those practices that they enter into.
Mm-hmm. Okay.
But I'd be happy if we do physicians, Mr. Chairman.
Okay. All right. Otherwise, you still support the bill?
Mr. Chairman, we don't have any problems with the bill.
Okay.
No.
Right. Okay. Good.
Thank you.
Anything else? Come in. Thank you very much. Oh, Representative Oakley does have a question. Sorry.
Thank you, Mr. Chair. So I wanted to talk about the renewals again. So do you do the with physicians? I've heard about it with nurses. Do the physicians also have to renew their non-compete clause every time they're signing on again?
Mr. Chairman, Representative Oakley, it's part of the conversation when contracts are renewed. And I think each individual situation is different based on length of time, length of tenure in their position, how long they've been with the practice. It's all over the board, but it is part of the negotiating. And I can speak to it freely because I was a hospital administrator. We had some of these in our contracts, and it was one of the things we talked about. And it wasn't like the physicians or practitioners didn't know that it existed. It was part of what we discussed when we renewed their contract and looked at overall compensation and other things. So it's all part of the contract. Now, I'm not saying there aren't automatic renewals in place in some of the facilities around the state, but we haven't done a deep dive into what each of those look like. We could do that if you wanted us to. Thank you.
Welcome, Tammy.
Good morning, Mr. Chairman, members of the committee. My name is Tammy Johnson. I'm the Executive Director for Wyoming State AFL-CIO. I appreciate the bill that's been brought before you today. It's on its face, great idea, great concept. We do favor employees being able to have mobility in the workplace. As Representative Stitt pointed out, one of the concerns I have is on page 5, Romanet capital B, the employer's actual cost of hiring a bonus paid to an employee. I brought this up to him. We've been talking about it for a while about low wage workers and the impact that that would have in the current marketplace. Bonuses are being offered in industries where they typically haven't been. We talked about fast food, the restaurant industry, fitness gyms, all kinds of industries are offering hiring bonuses. And the way those are often paid out is over time. So if you go to a fast food joint and they say, we're giving $1,000 hiring bonus, you don't get the $1,000 up front. It's paid out over time. So if you work a month, you get a month's portion of that bonus. So to think that that could be clawed back because you left before 3 years to go maybe across the street to another fast food joint that maybe is offering a little more, is tough to swallow, because the way that would be picked up by the employer is through the last paycheck. They're not going to litigate. They're not going to come after you and say, we're going to sue you. You have to pay us back. They're just going to keep your last paycheck. And so you get to go without a paycheck for a week or two, whatever that pay period is. So it's concerning. And I know that the bill says if you've signed an employment agreement, and I actually contemplated going out to apply for a job yesterday to see if there was an employment agreement. It varies among franchises. So some places do require a signed employment agreement, some don't. So it would just depend. And I could see that this legislation could inspire a quick signed employment agreement if a company knew they could claw back a bonus. If someone left before 3 years was up, that's a long time for a lower wage worker to stay at a place. And so I like the notion of that, of putting in on line 14 after the word bonus of more than $5,000. That's kind of the peak bonus that I've seen in some of these lower wage jobs. Typically it's $500 or $1,000, but it would protect some of those workers who maybe receive that kind of a bonus. That would be my preference as a kind of a friendly amendment to the bill. And I think that the bill sponsor is amenable to that. Our lower wage workers are at an extreme disadvantage right now. And I think we need to do everything we can to help them. And I think this bill allows the mobility to move. It allows people who typically sign non-competes the ability to move, but it also protects the things that those workers need. So I'm happy to answer any questions.
Committee? I think you answered their question at
All
the
right.
very end. They're just
Yeah.
waiting on the dollar amount.
Thank you. Yeah, that's great. I do worry. We don't know the unintended consequences of something that's stated as broadly as this. So I'd just like to build in a little protection for some of the workers that may not be acknowledged through the intent of the bill. So
Very good. Very
yeah,
helpful.
thank you. Yep.
Anyone signed up in the virtual world, Carol? Contractors?
Good morning, Mr. Chairman. My name is Jason Tysted. I'm the branch manager for S&S Builders in Gillette. With me this morning, I have our attorney, Amanda Esch, who will be testifying on our behalf. So with that, I would like to turn it over to her for comment.
Thank you, Jason.
Good morning, Mr. Chair, members of the committee. Thank you for your time this morning. I guess I want to start by saying, or give you a little background. I'm an attorney based here out of Cheyenne with Davis and Cannon. I do a lot of employment work and represent a lot of businesses around the state. So I'm pretty familiar with non-competes. And one of the things that sort of drives me crazy currently is when I'm talking to opposing counsel oftentimes, or people in the community, and they say, well, non-competes just aren't enforceable. Everybody knows that, which is a misconception. They are enforceable, and I've gotten them enforced before. But the thing I guess I would start by saying is that the way that the case law currently stacks up, they're only enforceable if they're reasonable, and they have to be reasonable in duration, in the limitations, the type of employee that they're directed at. And so I think on behalf of SNS, and I think I can say on behalf of some of my other clients, I think it makes a lot of sense for the legislature to put in place a bill more clearly delineating what non-competes are enforceable and potentially which ones are not. So, we're certainly not opposed to that effort. I guess to the comment about stakeholders that Mr. Bully made and Chairman Olson pointed out, a business like SNS Concrete is one of those that I think potentially is left behind in this bill. So what we're asking for today is, if the bill is going to move forward, we would request that you all consider a couple amendments. The first of which being that non-competes be allowed in the case of an ownership interest in the company. That's the primary manner in which SNS utilizes non-competes. So, and I would completely agree with what Mr. Stith said, as well as the executive director of the union organization. Non-competes should not be utilized with lower level employees. They should not be utilized with fast food workers. That's a completely inappropriate use of these types of contracts. They are supposed to be utilized for highly compensated employees that are having very special confidential information, trade secrets, that they are being trained up, that there's being a lot of time, money, and effort invested in these people and bringing them up through the company. And I will say that's exactly what SNS does. So Mr. Tysted could probably speak of it from his own personal experience, but many of the employees in SNS worked up, and after a certain period of time of employment and responsibility, were offered the opportunity to purchase shares in the company. That's really important for their business model, in large part from the standpoint that they want their employees to be able to have that access. They want them to have that ownership of the organization. It helps them as a company to grow. It helps them promote people from within for a lot of reasons.
Ms. Esch?
Oh, yes.
Have you emailed us these amendments that you're talking about?
So I think there was a little confusion. We actually provided the amendments that were provided from the Contractors Association.
So yeah, okay. So we've got them somewhere here.
You do. It was the attachment that Representative Stith was referring to. And I'm happy to go through those individually if that would be helpful. If you want to start there.
Well, in the interest of time, honestly,
Absolutely.
I get 30 minutes to work this bill. We held it over interim, so we've kind of all the policy and stakeholders and all that we're well aware of. And actually, I've been talking with we spoke earlier this week, so we're very interested in seeing your amendments and trying to make it workable. So if we can just jump to those, that might.
Absolutely.
I have no issue with that.
Yeah, so I'm going to skip over for now the executive personnel definition. I agree, though, that does need to be defined. We've offered a more broad definition than Representative Stith has offered. But if you are to reject the definition we've proposed, which does include managers and other high-level employees with access to trade secrets. No,
I'm trying to get the amendments in front of me. My inbox is insane.
yeah, I can't imagine. So, Mr. Chair.
I just have an auto, everything Clark sends me. I goes to spam.
It's understandable, Mr. Chair.
Go ahead, Ms. I'm sorry.
So our definition of executive personnel, which is provided in our materials to you, is more broad in that it includes managers, and it also includes high-level employees with access to trade secrets or specialized information specific to the business. In the case of SNS, the only employee in our organization that I'm aware of that would fall under that definition of the trade secrets is our bidding staff, our estimators. And that's where I think from the viewpoint of our industry, that's where things like, I understand what Representative Stith is saying regarding classifying things like client list is a trade secret. That's a really easy thing to enforce. If someone leaves your employ and they're a salesperson and they immediately start calling all the customers and they switch over, yeah, Bob's your uncle. Like, we know that's happening. In the case of SNS, they have worked tirelessly for years and years and years to perfect their bidding process. They're in a highly competitive industry. They're bidding projects both as a concrete sub and as a general throughout the state on a regular basis. And they've worked super hard to perfect those numbers. There's a ton of legwork and number crunching that goes into it. Those are all proprietary trade secrets that are closely held in the organization. And if one of our estimator leaves and goes to work for one of our competitors, it puts us at a huge disadvantage. And it's extraordinarily hard for us to police that. I have no way of knowing that, like, there's not going to be some, like, if we lose the bid when our estimator went over, I mean, there's almost no way for us to track down how they arrived at their bid. I mean, really, in that case, what we would be faced with is filing a lawsuit, which I think the whole point of putting this bill in place is to try to cut down on the amount of litigation around non-competes, or one of the points of it, I would think. And so as much, when we're in that situation of trying to basically police something that's really difficult to prove, it's going to put us in a tough position, certainly. So that's one amendment that we'd request that you consider. Then the other main one that we're requesting is on page 5. We would request as a substitution in line 3, a new Romanet 4, or excuse me, a new Roman numerat 4, including any owner of a business entity. And in that case, in S&S's case, we're asking for that because that is a situation where an employee issue is not at a disadvantage. They're being offered ownership stake in the company. They have no obligation to take that. That's an arm's length transaction. If they want to buy into SNS, they are required to sign a non-compete at that point in time. The rest of their employees, unless they're in these highly confidential positions, they're not being asked to sign non-competes. We have no interest, again, in keeping laborers from moving to a different company. I mean, obviously we want to retain them if we can, but we're not doing it through these types of contracts. We're trying to do it through good work conditions and incentives and good pay. So there's some other, I'm happy to go through the other proposed amendments, Mr. Chair, if that is what you'd like to do, but I don't know in the interest of time if that's.
If there are things you want to change about this bill,
Okay.
now is the time to do it.
Thank you, sir. So following up, I guess going back to page 4, we have asked that or assets be inserted after goodwill regarding the sale provisions.
Ms. Esch,
Yes.
my question on that is just qualifying assets. Did you hear Representative Stitt's testimony that maybe we qualify it as substantial assets, so it's not you sell off one thing?
Loader, yeah.
Yeah.
I don't think that would be a problem. Yeah, we're not contemplating, it's more if you're basically selling the assets of the company. So I don't think we'd be opposed to a substantial being placed in there.
Okay.
Going to the next page on 5, line 1, executive personnel, we would ask that directors be inserted into that definition after executive personnel, just to contemplate basically the different types of structures for corporate entities throughout the state. And again, those are going to be the people that are getting that highly confidential information in board meetings and things like that. Okay, then going back down to line 20, we would request that where carry on appears in the bill, just to make that more clear, that the language own, manage, operate, join, manage, or become an employee of a be inserted there as opposed to the current. Line 23, we would ask that after business, a comma and assets be inserted consistent with our other requests. Following page 6, line 10, there's another carry on, and we would just ask for the same definition to be inserted there. Line 23, same definition, except in that case, adding ing at the end of those verbs. And then on the last page, page 7, line 4, assets inserted in front of goodwill, just consistent with our other requests.
All right.
Okay. At this time, I'm happy to entertain any questions you may have.
Committee, do you have questions for Ms. Esch? Or for SNS?
Okay, I'm gonna.
Come on.
Representatives Wanitzer.
Thanks. And so you testified that we maybe do need more, I don't know, something more robust in our law, that there are situations, and it would be nice to further kind of delineate. I guess my question is, do you think we can get there with this bill? I mean, I've reading through some of your amendments. I think they're good in this case. I'm gonna probably hear that some people say that they might not be beneficial in their case. And so as I'm thinking how this is going to go, my question is, do you think this vehicle this year ready for prime time? And if we amend it with your suggestions, there won't be any further amendments in coming years, or as you read through it, does it still need some more work and more research in your mind?
I think Representative Zonitzer's question is, if we include your amendments, will we have created the perfect bill that will never need changed?
Something like that, yeah.
Thank you, Mr. Chair. Representative Zwanitzer. If these amendments are included, I think it would go a long way towards helping and clarifying. And I'll echo also what Mr. Boley said. I do think there's a place for non-competes with highly compensated employees as well, like physicians, for example. If the committee was interested in tabling it for now and going back, I mean, that's certainly, I apologize that we're sort of late to the party here, but it's something I know my client here today and some of my other clients would be happy, that we would happy to work with you to develop additional more clear language. I think it serves everyone's interest again to have this be as clear as possible. So
Yeah, Ms. Esch, I don't think tabling it allows for the policy question. Working through your amendments, they're not policy, they're very little policy related.
Yeah.
I think in general, Mr. Boley is presenting a policy question that the legislature should weigh in and should answer. And
Yeah.
we, as this committee, we may specifically choose to answer it if we, for example, were to, if we table the bill. I feel like we are answering that policy question on behalf of the entire body. If we were to create certain exceptions, we may be weighing in on that policy choice. But I think what you're suggesting, what Mr. Boley is suggesting, is certainly it's an absolute shift from where Wyoming law exists, and that is a policy question. And I'm quite comfortable with if the House of Representatives feels that policy shift, that the exceptions would swallow this rule anyway, and they should be so broad, and there are appropriate places, then maybe that does warrant a completely different look at the legislation. But I think it's an appropriate policy question to allow the House of Representatives to weigh in. From a committee standpoint, at least I guess I'm almost providing my insight on why I want the bill to move forward. But I want stakeholders to, I definitely want to work through these amendments and get it to a place where we have at least comfort with our existing language. But the policy question is obviously such a bigger debate, right?
yeah, exactly, Mr. Chair. And again, I applaud you for taking this on. I realize it's an area I get a lot of calls on. And I think there's a lot of misinformation about the current state of the law. And even if you're familiar with it, it's open to a lot of interpretation, and it's going to be subjective every time, and you're going to give a judge a call. And I think this at least allows the judges and attorneys and business owners in the state to have a little bit more clarity. So if, we're certainly in support of the bill if we can get it to move forward with these proposed amendments. So
Wish we would have had you during the interim.
I wish I would have been paying closer attention, Mr.
But I know
Chair.
what it's like to have a busy practice.
Yeah.
I understand. You're not just sitting around waiting to see what the legislature's doing.
Apparently I should be. I don't know. I need to track it a little closer, sir.
We appreciate you weighing in at this point, Ms. Esch.
Okay.
Additional questions? All right. Thank you both.
Thank you for your time.
Any other public comment on this bill? Any other public comment on this bill? Anyone, Carol, who has become excited in the virtual world about our conversation? No.
The only attendee that's still in there is Donna Creech, and somehow I don't think she's not raising her hand.
Oh, Danielle Creech
No,
or Donna Sheen?
Donna Sheen, yes.
Oh, yeah, I don't think Donna's interested in this. I could be wrong. All right. With that, I will close public comment. Committee, what is your pleasure? Okay. Don't get too excited here.
Move the bill, sir.
Thank you, Vice Chairman Washit, and you want to second it, Representative Provenza? Okay. Yeah, I know. All right, committee. Let's see. Let's just go page by page. There's a lot here. Unless, I don't know, I suppose I would take up, given the time, I would take up different considerations in terms of a global, any type of global amendments that you're contemplating at this point, given what you have in front of you. If not, we can just go page by page. You basically have, you have amendments coming from different folks. You don't have to amend this bill at all. You can adopt, you can globally adopt all of what somebody sent you, or it's in the form of an amendment, technically the way that bill is, or we can go page by page if you prefer. Well, we could do this, committee, if you were interested in offering a global amendment. Then once we have that, we can amend on the global amendment if there's certain things that, you know, one or two that whatever you want to play with. Yeah. Representative Williams.
Thank you, Mr. Chairman. I move the global amendment provided by Ms. Aish. And move that we adopt those.
Okay, seconded by Representative Oakley. And Carol, you have a copy of this or no? You do not have a copy of this. Okay. Will someone who has it up on their phone just forward it to House Judiciary 1 right now, please? Yes, Representative Oakley, please.
Thank you, Mr. Chair. I don't know if I can't see that it's intentional, but on that, manage is listed twice in every single one of those. So as far as, I guess, I don't know how to do the motion on the floor said generally adopt those, but just to clean it up, I would move that we take the second manage out of all of those.
Okay. That seems friendly to the sponsor. That is friendly. Representative Craigo.
Thank you, Mr. Chairman. The same issue on page 3, estimating is listed twice. The bottom of page 3.
Okay. That's friendly too. Let's just clean up. How about a qualification on assets? Representative Yen.
Mr. Chairman, in the amendment where assets is added, I would move that we change that to substantially all assets.
Okay.
Where's Carol's assistant? We specify that?
It appears, I think 3 different times or so in the bill. So Carol, eventually you're going to have in front of you our bill with red writing in it. Do you have that?
I do have it, but I didn't have it when people started talking.
That's
So
okay.
I'm a little
I'm
lost.
taking notes, so I will circle back.
Thank you.
Basically, if you've got it anywhere that we have the inserted language managing and estimating appear duplicative, we just need to delete the extra word. So that one's pretty straightforward.
And which one are we deleting? Is it the managing or the estimating?
both. So
both of
anytime
them.
managing appears twice where the amended language exists, we only need it to appear once.
One time, okay?
Mhm. And anywhere estimating appears, we only need it to appear once.
Okay. And then with assets, what was the?
Yep, so where assets appears in red writing, in front of assets, you will insert substantial.
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 Mr. Chairman, it was substantially all because that, we have a definition for that in the bill.
Substantially all
Substantially.
of the assets.
Oh,
Substantially all of the assets.
okay.
Okay. You need a second on that. That's a little more substantive, or you just take it as a, well, let's take it as a friendly. It's fine. Representative Yin.
Mr. Chairman, so I'll start making amendments that have some policy differences from the contractors, if that's okay.
Yep.
So on page,
Sorry,
Are these going to be friendly amendments to the motion, or should we move the?
he's amending the amendment.
so it is an amendment to the amendment, but I would be happy to
Would you,
do it after if you want to vote on the full amendment first. It's up to the chair.
I
How we
think
proceed.
what will be cleanest for Carol's notes over there is that she's gonna have one clean copy. So I would be okay with just amending the amendment if everyone can follow and track. If it gets too messy, we'll back out of it, but I think it'll work. Go ahead, Representative Yang.
So, Mr. Chairman, on page 5, line 3 of the redlined contractors version, they add any owner of a business entity. I would change that to any owner of more than 5% of a business entity, so that small stock purchases aren't forcing someone to be forced into a non-compete.
Or, yeah, it's actually interesting because I'm thinking of the threshold for IRS purposes is 20%. I think it's actually 20%. So generally, if you're under 20%, you're considered a minority holder.
So, Mr. Chairman, that
Is
would
it
be
10?
friendly.
10% for our ethics.
For ours?
Yeah.
Mr. Chairman, I'm fine with 10%.
10%?
10%.
Okay.
And that would go after the or?
Mr. Chairman, so it would be on page 5, line 3 of the red line where they add Romanet 4, any owner of a business entity, or, so instead of, it would read any owner of at least 10% of a business entity. Or.
10%. Okay. thank
Any
you.
owner with at least a 10% interest in a business entity.
That's friendly, Mr. Chairman.
Is there a second on that motion? Seconded by Representative Provenza. Discussion on this amendment. Representative Cragos.
Thank you, Mr. Chairman. I guess my problem with the proposed amendment is there are certain companies that are worth millions of dollars. I think we have one sitting in the room probably, and a 1% interest in that company is very valuable. And so it's hard to put that number at 10, 5, whatever. Then, I mean, that's my problem with the amendment. I understand where we're trying to get with it, but I think it's going to drastically affect their view of the bill if we change that to a certain percentage. I don't know how to fix the problem. I just see the problem with the amendment.
Further discussion on the amendment? Representative Yin.
Mr. Chairman, it's possible that we could just put a dollar amount on how much they own rather than a percentage. I'm comfortable with 10%, but I know if others aren't, feel free to vote it down and change it or whatever the committee desires. Thank you, Mr. Chairman.
Okay, further discussion on the amendment? All those in favor of the amendment signify by saying aye. All those opposed? That amendment has failed. Any just on this topic in specific, any other amendments on this amendment? No, okay, other amendments? Representative Yin?
Mr. Chairman, I would move that we change the proposed definition of executive personnel to the one that Representative Stith proposed in his email.
Okay. Moved by Representative Yin and seconded by Vice Chairman Washit. Discussion on the amendment, Vice Chairman Washit.
As I heard Representative Stith talk about CEO, COO, president, we didn't mention the CFO. And in my book, the chief financial officer would be in the same category, and I would offer to include that as well.
Is that friendly?
Mr. Chairman, that's friendly.
Carol, do you have Representative Stith's definition?
I think I do. I think I wrote it in here. This is on which page? Okay, so it's Chief Executive Officer, CEO, President, and then someone else had said directors, which I believe is in the red.
That's already, yeah,
Yes.
been inserted. Mhm.
So include all of those. Is that accurate?
Mr. Chairman, so it wouldn't include directors because directors are in a different part of their amendment. So it would be Chief Executive Officer, Chief Operations Officer, Chief Financial Officer, or President.
Financial? Okay.
All right. Ready to vote on that amendment, committee? All those in favor signify by saying aye.
Aye.
All those opposed? That amendment has been adopted. It's showtime in 7 minutes, committee. You better be awake for 10 o'clock. All right. Yeah, it's almost there. Yeah, Representative Provenza.
Thank you, Mr. Chairman. I would like to add on page 5, line 14, insert after bonus of more than $5,000 paid to an employee.
Okay. Representative Yin. That's why I put Representative Yin and Representative Provenza on the far ends of the left and the right, is because I can actually see them easier for all of the amendments and seconds that they provide to this committee.
And it would be greater than 5,000. Is that correct?
Yes, of more than $5,000.
Thank you.
Discussion on the amendment. All those in favor signify by saying aye.
Aye.
All those opposed, that amendment, oh. All those in favor signify by saying aye.
Aye.
All those opposed,
No.
that amendment is adopted.
It's passed.
All right. Additional amendments. Vice Chairman Washit.
I would offer an amendment on page 5 of the bill that before executive personnel, we insert the word physician, comma,
All right, that has been, we have a motion from Vice Chairman Washit and a second from Representative Oakley on page 5 in front of executive personnel to insert physicians, comma. If I had my way with this amendment, I would make sure there's that the Oxford comma is in use as well, but it's not my amendment. All right. Discussion on the amendment. Representative Yin.
Mr. Chairman, just a comment. So this is something that is actually playing out in Teton County. However, in our situation, it is a clinic that was purchased where the physician was the owner of the clinic. So that physician would not actually fall under because they would be exempted as an owner of the business entity. In that situation, I'm not sure how I feel about the amendment of just adding physicians point blank, but that's one situation where it is playing out right now.
Additional discussion on this amendment? Vice Chairman Washington.
Just very quickly, Mr. Chairman, physicians really do have bargaining power. They're not like a lot of lower level employees and organizations. And I think they are more akin to having the leverage that a CEO or COO might have.
Additional discussion on this amendment? Ready to vote? All those in favor signify by saying aye.
Aye.
All those opposed?
No.
That amendment has failed. Additional amendments? Additional amendments. All right. Any other discussion on this bill? Carol, will you please do a roll call vote on House Bill 38, Contracts in Restraint of Trade?
Representative Craigo. Representative Larson has submitted an absentee vote of aye. Representative Oakley.
Aye.
Representative Provenza.
Aye.
Representative Rodriguez Williams. Vice Chair Washit.
Aye.
Representative Yen.
Aye.
Representative Zawannitzer. Chairman Olson.
Aye.
6 ayes, 3 noes, do pass with amendments.
Very good. Carol, you feel good about tracking that amendment?
I'll work on it.
Apologize in advance. That's not normally how we work amendments. But Ms. Esch, just as a future note with something like that, if working through a representative, they can get it into LSO language prior to the meeting. And then that's just easier on our secretary is all. We are adjourned.